An eviction is a lawsuit that a landlord must file to retake possession of an occupied residential rental unit. An eviction can be filed because your lease term has expired, you did not pay rent within 5 days of the due date, or you did not comply with some other requirement of the lease. Before filing the eviction, the landlord has to give you notices. In other words, tell you that they are planning to evict you and why. How eviction starts. Notice. For example, if you're being evicted for not paying rent, they need to send a 5-day notice telling you that they are planning to evict you. If you violated your lease, so long as the violation doesn't affect health and safety, they must send you a notice giving you 14 days to fix the problem. If your lease term expires, the landlord doesn't need to give you notice unless you're on a month-to-month or week-to-week lease, in which case the landlord needs to give you 30 days or 7 days notice that the lease won't be renewed. Once the landlord has sent the notice, he files something called an application for ejectment with a local magistrate court stating why you should be evicted. This starts the lawsuit. The tenant is notified too. It's called being served. The magistrate sends you a rule to vacate or show cause. The rule should inform you of the reason that the landlord wants to evict you. You then get 10 days to respond. You can respond in one of two ways. Either 1. Vacate the property within 10 days after the rule is served on you, or 2. File something called an answer to request a hearing before the magistrate court within the 10 days. If you do neither, you'll be in default. The magistrate court will issue a writ of ejectment, which is the court order that says law enforcement can physically put you out. Basically, you lose automatically because you don't defend yourself. If you have reasons why you should not be evicted, called defenses, then it's a good idea to write these down in your answer and file these at the magistrate court as your response to the rule. A defense is a legal reason why you should not be evicted. Common examples are 1. You did not do what the landlord says you did, including you actually paying the rent. 2. You did what the landlord says you did, but that does not count as a breach of the lease, like the landlord tries to evict you for having a pet, but the lease doesn't say you can't have a pet. 3. You did what the landlord says you did, and what you did breached the lease, but it's really minor. 4. The landlord did not give you all required notices. Defenses can be technical. You should consult with a lawyer for these. The hearing. After you request a hearing, the magistrate court will let you know when to come to court. The hearing is a trial. The magistrate will not investigate to figure out whether what your landlord is saying is true or false. You must be able to explain to the magistrate why the landlord is wrong. If the magistrate finds against you at the hearing, then he or she will issue that writ of ejectment within 5 days of the hearing. The constable must physically post this writ to the property. This starts a 24-hour clock. If the unit is not vacant 24 hours after the writ is posted, law enforcement can return and physically evict any remaining occupant. Eviction cases can be challenging. We strongly advise you to seek legal advice or representation if possible.